It will be useful to refer to certain judgments of this court on violation of procedural law, which are as follows. 1. Sardar Amarjit Sinha Kalra vs. Pramod Gupta, 2003, 3S72, Constitutional Bench, Para 26. Laws of procedure are meant to regulate effectively, assist and aid the object of doing substantial and real justice, and not to foreclose even an adjudication on merits of substantial rights of citizen under personal, property and other laws. Procedure has always been viewed as the handmaid of justice, and not meant to hamper the cause of justice or sanctify miscarriage of justice. 2. Kailash vs. Nanhaku, 2005, 4 Sisi 480, 3-judge bench, Para 28. All the rules of procedure are the handmaid of justice. The language employed by the draftsman of processual law may be liberal or stringent, but the fact remains that the object of prescribing procedure is to advance the cause of justice. In an adversarial system, no party should ordinarily be denied the opportunity of participating in the process of justice dispensation. Unless compelled by express and specific language of the statute, the provisions of Code of Civil Procedure or any other procedural enactment ought not to be construed in a manner which would leave the court helpless to meet extraordinary situations in the ends of justice. The observations made by Justice Krishna Iyer in Sushil Kumar Sen vs. State of Bihar, 1975, 1 SCC 774 are pertinent. The mortality of justice at the hands of law troubles a judge's conscience and points an angry interrogation at the law reformer. The processual law so dominates in certain systems as to overpower substantive rights and substantial justice. The humanist rule that procedure should be the handmaid, not the mistress, of legal justice compels consideration of vesting a residuary power in judges to act ex debito justitiae, where the tragic sequel otherwise would be wholly inequitable. Justice is the goal of jurisprudence processual, as much as substantive. In State of Punjab vs. Shamlal Murari, 1976, 1 SCC 719 the court approved in no unmistakable terms the approach of moderating into wholesome directions what is regarded as mandatory on the principle that processual law is not to be a tyrant but a servant, not an obstruction but an aid to justice. Procedural prescriptions are the handmaid, and not the mistress, a lubricant, not a resistant in the administration of justice. In Ghanshyam Das vs. Dominion of India, 1984, 3 SF 46 the court reiterated the need for interpreting a part of the adjective law dealing with procedure alone in such a manner as to subserve and advance the cause of justice rather than to defeat it, as all the laws of procedure are based on this principle. 3. Sugandhi vs. P. Rajkumar, 2020, 10 SSA 706 Para 9. It is often said that procedure is the handmaid of justice. Procedural and technical hurdles shall not be allowed to come in the way of the court while doing substantial justice. If the procedural violation does not seriously cause prejudice to the adversary party, courts must lean towards doing substantial justice rather than relying upon procedural and technical violation. We should not forget the fact that litigation is nothing but a journey towards truth, which is the foundation of justice, and the court is required to take appropriate steps to thrash out the underlying truth in every dispute. Therefore, the court should take a lenient view when an application is made for production of the documents.